So, hello and welcome back to my channel. And today we're going to read the foremost book for covering Indian polity, which is class 11th Constitution at Work. So, I've made these concise notes on this whole book. So, let's cover all of this book in one stretch. So, first of all, the functions of Constitution. The function of Constitution is to provide a set of basic rules that allow for minimal coordination amongst members of the family, sorry, amongst members of the society. So for family, it would be constitution for the house. Anyway, the second is function is to specify who has the decision making powers and decides how the government will be constituted. Third is set some limits which cannot be trespassed on what a government can impose. Fundamental rights cannot be violated. This is an example of what limits can be placed upon the government which it cannot trespass. Fundamental rights cannot be violated. These are only limited during national emergency norms. Then, the fourth function is it enables the government to take positive welfare measures, some of which are legally enforceable. So, for example, the reservation or the abolition of sati. So, positive welfare measures. Also, some of the DPSPs like Article 39B and C. The fifth function it offers is that it gives political, moral, and national identity to its citizens. So, first is to set basic rules, then specify who has the decision making powers, then set some limits on the people who are going to make those decisions, like that is the government, and then enable the government to take some positive welfare measures. And after that, to give a political, moral, and national identity to its citizens. So, constitution is a compact document that comprises a number of articles about the state, specify how the state is to be constituted and what norms it should follow. So, the enabling provisions of the constitution are an example of that of South Africa. So, these provisions are basically a derivative of those which were followed in South Africa. In South Africa, where you have to provide better standards of living, conserve nature, etc., and Indonesia as well, in order to establish and conduct national education system. So, India's constitution. It was formally created by the Constituent Assembly, whose term was from December 1946 till November 1949, 26 November 1949 to be precise. It drew upon a long history of nationalist movement like the South Africa, the US, and obviously the Indian freedom struggle. So it was never subjected to any referendum. It carried enormous public authority because it had the consensus of the popular leaders. It is horizontally fragments power across different institutions like the legislative, executive, and judiciary. So this is separation of powers. Then it is a living document. It strikes a balance between the possibility to change the provisions and the limits on such changes. Then it has an intelligent systems of checks and balances. The parliamentary form and federal arrangement, the provisions of other countries' constitutions suited for India. For example, we have taken the fundamental rights like from the US, the prerogative rights from British, the parliamentary system also from the British. We've derived the DPSP from Ireland and many such examples of it. Then the Constituent Assembly. The first meeting was held on 9th December 1946 and it reassembled as Constituent Assembly for divided India on 14th August 47. Members were elected by indirect election by the members of the provincial legislatures, and from the princely states they were actually nominated by the princes themselves. And assemblies that had been established in 1935 along the rules of the cabinet mission. The provinces and princely states were allotted seats and in accordance to their populations. So in proportion to their populations, 1:1 million, 1:10 lakh basically, distributed among three main communities which were Muslims, Sikhs and general, with votes for their respective representatives and single transferable votes. One vote, one value. So the provinces had 292 members and princely states 93 members. Dr. Rajendra Prasad echoed the formation of the Constituent Assembly, but it was like as far as I remember, in Lakshmikant it has been given that M.N. Roy was the pioneer who first gave the idea as to the formation of the Constituent Assembly. So, but this is given in the NCERTs. Anyways, after partition from 3rd of June, total assembly seats were in India were 299, 284 were present on 26th of November 19. This date is wrong. And state SC members were 26, scheduled caste members were 26, 82% were Congress seats. Every matter was debated thoroughly except the universal adult suffrage, subject to public reason, and it took a total of 166 days, 2 years and 11 months. Sessions were open to public and press. So, some of the provisions which were borrowed from other countries. So, from the British Constitution, we borrowed the FPTP, which is first past the post system. Then the parliamentary form of government, the idea of rule of law formulated by A.B. Dicey. Then the institution of the speaker and its role, the law making procedure. So, this were from the British Constitution. And then from the Irish Constitution, we took the DPSP. From US Constitution, the Charter of Fundamental Rights, power of judicial review. Although the power of judicial review for the American courts is much broader than that of our judiciary in India. We also took the independence of judiciary from the Constitution of US. Then the Canadian Constitution, we borrowed the quasi-federal form of government, a federal system with a strong central government, so central stronger than the states, and the idea of residual powers. So the residual powers can also be taken from the Government of India Act of 1919-1985. It also had the residuary powers. Then the French Constitution, we borrowed the principles of liberty, equality, and fraternity, which evolved from the French Revolution in the late 18th century. So, the objective resolutions, these were given by Jawaharlal Nehru in the first session in 1946, the first session of the Constituent Assembly. It defines the aim of the Constituent Assembly, derived from principles of national movement. So, objective resolutions also are inculcated or are imbibed within the preamble. These are inculcated in the preamble. Then, the fundamental rights in the Indian Constitution. In 1928, Motilal Nehru Committee demanded a Bill of Rights. So, the Nehru Report basically had a demand for the Bill of Rights, Bill of Civil Rights. Then, the fundamental rights cannot be violated by the government, except in certain situations. There have been some exceptions given around that also. But generally, it cannot be violated by the government. The ordinary rights are protected by the law, whereas the fundamental rights are protected and guaranteed by the Constitution itself. So, the ordinary rights may be changed by the legislature by ordinary lawmaking, whereas the fundamental rights may only be changed by amending the Constitution as per Article 368. Then, judiciary protects fundamental rights from violation via Article 32 and 226 for the High Courts. So, government can put reasonable restrictions on the exercise of fundamental rights. Mostly, we can see an example of it from Article 19. Then, these are basically classified into 7 broad categories. First of them is the right to equality. The right to equality, within that right to equality, we have the articles 14, 15, 16, 17, and 18. So, from 14 to 18. So, Article 16.4 is for the reservation for backward classes. It is 15.4, not 16.4. 16.4 is for Uh, Equality in public employment. Constitution clarifies that government can implement special schemes and measures for improving the conditions of certain sections of the society. So this is Article 15, Clause 4, which was for the socially and economically backward classes, SCs and STs. Article 16 is basically equality of status and equality of opportunity. This is Article 16, equality of opportunity in public employment. Then the right to freedom. Uh, Liberty means freedom of thought, expression, and action. Freedom with constitutional constraints. The right to life and personal liberty, 21 from Article 21, 22, 23, and 24, and also 20 with respect to detention. So no one can be arrested without being told the grounds of arrest. So you must be told the grounds of arrest if you are being arrested. If arrested, they have the right to defend themselves. It is mandatory for police to take the arrested person to nearest magistrate within 24 hours. Right to live with human dignity, right to shelter and livelihood from Article 21. Then preventive detention, this is Article 22. A person can be arrested if the government thinks he is engaged in unlawful activity without the above procedures. Preventive law can be extended only for 3 months. This is as per NCERT. Any rights of the accused. No person would be punished for the same offence more than once. Uh, no double incrimination. Then law shall declare any action as illegal from backdate. So no retrospective laws applicable. So no person shall be asked to give evidence against himself. So no self-incrimination. Then the rights against exploitation. Rights against exploitation are given in 23 and 24. Abolition of bonded or forced labor forbids employment of children below 14 in dangerous activities or hazardous. And the right to freedom of religion mentioned from Article 25, 26, 27, and 28. So, it is the hallmark of democracy. Everyone is free to choose a religion and practice that religion. Also includes the freedom of conscience, freedom to profess, follow, and propagate any religion. Although there is no right to convert anybody, you cannot convert an individual into a certain religion. Then, government can impose restrictions in order to maintain public order, like banning sati, human sacrifices. So government can basically get involved in the religious matters if it is in order to maintain public order. And then it forbids forcible conversions. Cultural and educational rights, 29 and 30 from the Constitution. The rights of minorities to maintain their culture. All minorities can set up their own educational institutions to preserve and develop their culture. Government will not discriminate while granting aid to educational institutions on the basis that it is under the management of the minority. So government would treat all of the education institutions uh, likewise. So they would not discriminate while granting aid to educational institutions on the basis of them being managed by a minority. So the right to constitutional remedies. This right is mentioned in Article 32, and this is said as the heart and soul of the Constitution by Dr. B.R. Ambedkar. Right to approach High Court or Supreme Court to get any of the fundamental rights restored in case of their violation. The courts can issue various special orders known as writs. So these writs are the writs of habeas corpus. The court orders that the arrested person should be presented before it. It can also order to set free an arrested person if the manner or grounds of the arrest are not lawful or satisfactory. Then the right of mandamus, when the court finds that the particular office holder is not doing legal duty and thereby is infringing on the right of an individual. Then prohibition and certiorari are for the judiciary. Prohibition basically is issued by a higher court when a lower court has considered a case going beyond its jurisdiction. Certiorari is that the court orders a lower court or any other authority to transfer a matter pending before it to the higher authority of the court. Then quo warranto, it basically means by what warrant or by what authority. It is used to prevent illegal assumption of public office or usurpation of any public office by anybody. Then the National Human Rights Commission. It was established in the year 2000. It is composed of a former Chief Justice of the Supreme Court, former Judge of the Supreme Court, former Chief Justice of a High Court, and two other members who have knowledge and practical experience in matters relating to human rights. The Commission's functions include inquiry at its own initiative or on a petition presented to it by a victim into complaint of violation of human rights. So it can take a suo motu cognizance as well as somebody can present a complaint to it. Its function is also to visit jails to study the condition of the inmates, undertaking and promoting research in the field of human rights, etc. Cases related to custodial death, custodial rape, disappearances, police accesses, failure in taking action come under its jurisdiction or come under its purview, basically, not jurisdiction. Then it has a significant role to play in the Gujarat riot cases. It does not have the power of prosecution. It merely makes recommendations to the government or to recommend to the courts to initiate proceedings based on the inquiry that it conducts. So it is just an advisory body of some sort. Then the directive principles of state policy. Also, right to property was a fundamental right previously, but it was revoked and now it is just a legal right. Then moving to the DPSPs. The guidelines incorporated in the constitution, but they are not made legally enforceable. Right to education, formation of Panchayati Raj institutions all over the country, partial right to work, underemployment guarantees programs, and the midday meal scheme. These all are implementation of the DPSPs. Fundamental rights in DPSPs are complementary to each other. Fundamental rights restrain government from doing certain actions, while DPSP encourage the government to do certain things. The DPSPs are basically for socio-economic welfare. Fundamental rights protect rights of individuals. DPSP ensure the well-being of the entire society. The fundamental duties of the citizens. So these were basically incorporated in 1976 by the 42nd Amendment Act, and there are basically 10 duties. The Constitution does not say anything about enforcing these duties. Enjoyment of rights is not dependent or conditional upon the fulfillment of these duties. So the right to property. Originally, it was in the Constitution. There was a right to acquire, possess, and maintain property, but the Constitution made it clear that property could be taken away by the government for public welfare. Since 1915, government made any laws that limited this right to property. The government claimed that the rights can be abridged for giving effect to DPSP. The government claimed that rights can be abridged for giving effect to DPSPs. Basically, the DPSPs given Article 39B and C. So the court held that the view that fundamental rights were so important and sacred that they cannot be limited even for purposes for implementation of DPSPs. The government was saying that Parliament can amend any part of the Constitution. The court was saying that Parliament cannot make an amendment that violate the fundamental rights. Eventually, the Keshavananda Bharati case, it was decided that there are certain basic features of the Constitution and these cannot be changed by the Parliament. So, like these cannot be abridged, these basic features. So in 1973, Supreme Court gave the decision that the right to property is not a part of the basic structure of the Constitution. Thus, Parliament has the power to abridge this right by an amendment. In 1978, by the 44th Constitutional Amendment Act, it removed the right of property from fundamental rights and converted it to a legal right. The election systems in India. There are 543 constituencies with each representative. The candidate who secures the highest numbers of votes win. So the past the vote system. We follow this in our Lok Sabha elections or our state legislative assembly elections. So in this system, the winner need not secure a majority of votes. That is, whoever crosses the winning post first is the winner. So whoever just, even though by a single vote or even though by two or three votes wins, that is the winner. So you just have to surpass or you just have to outpass your competitor. That is the thing. So you just have to get the majority of the votes. So not in for terms of percentages, you just have in terms of numbers basically. So it is called a plurality system. It is based on candidate preference. Each constituency has one representative. For example, in UK and India, the reason for popularity of FPTP in India is it is simplicity. It is simple. The simplicity considering the large number of population, the diversity in India. Voters can hold accountable the representatives, offers a choice between candidates, give large party or coalition some extra bonus seats more than their share of votes would allow. So this is not just based upon the proportion of the votes a party could garner. This is about the winning candidate, whoever is able to garner more number of votes. Not it is not based upon the proportion or the percentages of votes a person could garner. Then it facilitates a stable government and also coalition governments. Then constitution makers thought that in order to encourage voters of different social groups to come together and win an election, this would be a more suitable approach. So different peoples from different groups would come together in order to win an election. So this would lead to coalition, more cooperation basically. Uh, it discouraged specific community target votes. So no specific community, even though community is majority in certain area, even that would not lead to the person actually winning. So it discouraged specific community target voters. It generally led to two-party system. Then the proportional representation. The proportional representation is basically used in our Rajya Sabha elections. The party gets the same proportion of seats as the proportion of votes. Entire country is one constituency based on party preference. So this system was based on the public preference, whereas this is based on party preference. The third and complex version of proportional representation for elections of president, vice president, Rajya Sabha, and Vihan Parishads is used in India. In proportional representation, the winner gets the majority of votes in terms of percentages. Then this is used in Israel and Netherlands. It has not clearly reduced. It has not reduced clear majority of seats. The constitution makers thought proportional representation would not give stable government, and they encourage this would rather encourage each community to form its own nationwide party in India. In proportional representation in Rajya Sabha, it is the third variant of proportional representation with single transferable votes. Every citizen has a specific quota of seats. These are indirect elections. So basically, the elected members of the state legislative assemblies vote for the elections of Rajya Sabha and they vote in order of the preference of candidates. So this is a rough formula of how the Rajya Sabha candidates are elected or what number of votes they have to garner in order to get a Rajya Sabha seat, in order to get elected into a Rajya Sabha seat. So the total votes filled upon the total number of candidates to be elected plus one, and then this whole factor plus one. So the votes are counted on the basis of first preference. If after counting of all first preference votes, the required number of candidates fail to fulfill the quota, the candidates who secure the lowest votes of preference is eliminated and his or her votes are transferred to those who are mentioned as second preference. So it is like a very complex one. Not so complex, but complex in terms of general public. Then, separate electorates. These were basically proposed in the Government of India Act 1919. So, separate electorates basically are the ones where only a certain community votes and uh, only their candidates get elected. So, separate electorates was for electing representative from a particular community. Only those voters would be eligible who belong to that community. So, this led to major contentions in the modern history. Then we have reserved constituencies. This was done initially for a period of 10 years, but it is extended later. And recently, so for this term, this was extended till 2030. All are eligible to vote universal adult suffrage. Everybody is eligible to vote. And it is not that only a particular community should vote. Everybody is allowed. But the candidate must belong to the reserved category. So the person who is contesting for the elections, that person should be from the reserved category, even though everybody else is voting. The number of seats are reserved in proportion to the SC/ST share in the population. In Lok Sabha, SC seats are 79, whereas the ST seats are 41. It is the reserved constituencies are basically decided by the Delimitation Commission. The Delimitation Commission is appointed by the President of India and works in collaboration with the Election Commission. It draws boundaries of constituencies all over the country. The constituencies with the highest proportion of STs are reserved for STs. For SCs, these are spread evenly throughout the country. The constituencies with highest number of STs also split these constituencies in different regions of the state. So these seats can be rotated each time the delimitation exercise is undertaken. So the seats right now are fixed till 2026, and the delimitation will be done after that, after 2026. Reservation for seats only in local government. So this is a previous information. Now we have the reservations in the legislature, state legislatures as well as the parliament. So Nari Shakti Abhinandan. Not sure if I have told you this the act correctly, but the seats reserved for the women in the parliament as well. This act was passed in 2023. Then the universal adult suffrage. Till 1989, adult male of 21 years old, adult Indian, not male, adult Indians of 21 years old, but after the amendment, it was changed to 18 years. So previously, there were only the adult males who were voting, but women eventually got the right to vote. And in 1935, there was some proportion of elected for like there were some proportions of women who could also vote. And in the Nehru report as well, which was prepared by Motilal Nehru in 1928, there was a provision for a universal adult suffrage. So, adult franchise ensures that all citizens are able to participate in the elections. All citizens have the right to stand for elections. For Lok Sabha, the minimum age is 25. For Rajya Sabha, it is 30. 2 or more years of imprisonment, then you are disqualified for contesting. So, if you are convicted for an offense and you have been sentenced to 2 or more years of imprisonment, then you are disqualified from contesting elections. So, the Election Commission, the article which facilitates the formation of Election Commission is the Article 321. It says that independent election commissions, superintendents, direction and control of the electoral roll and the conduct of elections in India are all managed by the Election Commission. The Chief Electoral Officer is present in every state in order to assist the Election Commission. The Election Commission is not responsible for local body elections. So the local body elections are conducted by the state election commissions. The Election Commission of India was a single member body till 1918. From 1993, it is a multi-member body. So one chief election commissioner plus two other commissioners. So chief election commissioner presides over the election commission. Chief election commissioner and two election commissioners have equal powers to all decisions relating to elections. These are appointed by the president on the advice of the Council of Ministers. Tenure of the chief election commissioner and election commissioners. are 6 years until the or till the age of 65, whichever is earlier. Chief Election Commissioner can be removed before the term by the President if both the houses of the Parliament make such a recommendation with special majority. So special majority is basically two-thirds of those present and voting and half of the total strength of the house, more than half of the total strength of the house. So more independent and assertive now. This body is more independent and assertive now because of using powers of constitution more effectively. So what are the functions of the election commission? It supervises the preparation of up-to-date voters list. It determines the schedule of elections. It can postpone or cancel the elections on grounds of no atmosphere for free and fair elections. It implements moral code of conduct for parties and candidates, can order re-poll, recount of votes, accords recognition to parties and allot them symbols. It take help of administrative machinery, has control of it from election beginning till it is done. It can transfer officers or stop transfers. It can take action against them for failing to act in a non-partisan manner. So the electoral reforms, these were the suggestions. The decisions were to change from the first past the post system to the variant of proportional representation. Proportion for one-third of the seats for women. So this is done. There was a question also in 2024 where we were asked about the women reservation in the parliament. The strict rule for roll of money. Nation expenses should be paid by the government out of a special fund. So electoral bonds were also in use last year. Then criminals should be barred from contesting. Ban on the use of caste and religious appeals. The laws to regulate functioning of the political parties. So moving on to the executives. Executives are the people who are responsible for implementation of laws and framing of policies. So the political executives are the heads of government. Ministers, permanent executives are the civil servants. So this is a chart about the type of executives. So first is a system based on the principle of collective leadership. Second is principle based on the individual leadership. So collective leadership is basically where two or more people are responsible for leadership, whereas the individual leadership is that the onus of all the decision making is on just one person. In collective leadership, we have two forms, which are the parliamentary form and the semi-presidential form, whereas in individual leadership, we have the presidential form. The presidential form of leadership is basically president is the head of the state. He is also the head of the government. So he is the head of the state as well as the head of the government. The president is usually directly elected by the people. He is not accountable to the legislature. So this is a very important point. So this basically the system is followed in the country of USA. Then we have the parliamentary system. The head of the government is usually known as the prime minister. He is the leader of the majority party in legislature. He is accountable to the legislature, and there are various modes of assertion of the uh, responsibility by the parliament. So there is no confidence motion and other tools as well. So the Council of Ministers is basically responsible towards the Lok Sabha. Then the head of the state may be a monarch or a president. So the head of government is a person who is elected, the person who has the majority support in the legislature. He is the leader of the majority party in the legislature. Whereas the head of the state may be a monarch or a president. So if it is a monarch, then the system is called a constitutional monarchy. Whereas if it is a president, then the system is called parliamentary republic. Republic, as in the head of the state, is from the people. It is the people who are the head of the state, and not somebody who has a hereditary position like a monarch. So both of these systems, constitutional monarchy or parliamentary monarchy, in both of these, the head of the state is just a ceremonial executive. So like de jure executive, whereas uh, The prime minister over here is the de facto head. So the semi-presidential system uh, has the president as the head of the state, has the prime minister as the head of the government. Prime minister and his council are responsible to the legislature. So both prime minister and his council are responsible to the legislature. This is semi-presidential system. So there is parliamentary form of executive in India. India follows the parliamentary form of government. The constitution vests the executive power of the union formally in the president. So president is the head of the state, whereas the prime minister is the head of the government. So all of the executive power is vested on the president by the constitution. So the president, Article 74 basically determines that the president exercises power through the councils of ministers, which is headed by the PM. He or she, the president, is indirectly elected by the MLAs and MPs through the proportional representation and single transferable vote. So, uh, basically, by the elected members of state legislative assemblies as well as Parliament of India and the UTs, the elected members of the UTs of Delhi, Puducherry, and so now the uh, Assembly of Jammu and Kashmir is also operational. So even Jammu and Kashmir. So he can be removed only by the parliament by the procedure for impeachment and requires a special majority. So this is a very different kind of majority. It needs 2/3 of the total strength of the house. President can ask the PM to reconsider his advice, but has to accept the reconsidered advice. uh, has wide-ranging power, executive, legislative, judicial, and emergency powers. So he also has judicial powers. So Article 356 basically is for presidential rules in any state, or which is also said as the state emergency, where situation has arisen in which the government of the state cannot be carried on in accordance with the provisions of the constitution. It can also be extended for a period of 3 years, maximum 3 years, within the discretionary power of the president. He has a right to be informed of all the important matters and deliberations of the Council of Ministers. The Prime Minister is obliged to furnish all the information that the President may call for. President can send back the advice of Council of Ministers and refuse and ask him to reconsider. She has veto power, but by which she can withhold or refuse to give assent to bill. Only for non-money bills. In the case of money bills and constitutional amendment bills, the president has to give her assent. So I'm trying to speak more in terms of the female gender because all the textbooks are basically written in the perspective of the males. So even the president, the prime minister has all the pronouns of his and him. So these things also needs to be changed. So anyways, every bill passed by the parliament goes to the president for assent before it becomes a law. Um, she also has pocket veto. There is no time limit within which the president must send the bill back for reconsideration. The president appoints the prime minister, who she thinks has a majority support. Then the vice president is elected for 5 years. The MLAs don't take part in the vice president election, so this is just done by the uh, Parliament of India. So just the Rajya Sabha and the Lok Sabha. Vice President can be removed by the resolution of Rajya Sabha alone, passed by majority and agreed by the Lok Sabha by simple majority. So resolution in Rajya Sabha. Then Vice President acts as the ex officio chief or the ex officio chairman of Rajya Sabha, takes over the office of President when there is vacancy. Then the Prime Minister, who is the head of the state. Sorry, who is the head of the government? The head of the state is President. So, the Prime Minister should have the support of the majority in Lok Sabha, decides the ministers and allocates then ranks and portfolios. If someone becomes a Prime Minister or uh, PM, if someone becomes a minister or a Prime Minister without being a member of the Parliament, such person has to get elected to the Parliament within 6 months. Before the 91st Constitutional Amendment Act of 2003, the Council of Ministers shall not exceed the 15%. So now there's a norm after the 91st Amendment Act of 2003 that the Council of Ministers should not exceed the 50% of the total number of the members of the House of People. So 15% of the members of the Lok Sabha. So 15% of 543. So, a vote of no confidence, even against a single member, leads to the resignation of the entire Council of Ministers. The death or resignation of the President, the death or the resignation of the Prime Minister automatically brings about the dissolution of the Council of Ministers. Pandit Nehru describes Prime Minister as the linchpin of the government, as the one who basically forms a link between the executive part as well as the legislative part of the government. Then the powers of the Prime Minister, he controls over the Council of Ministers, the leadership of the Lok Sabha. So he is the uh, leader of the House in Lok Sabha, and in Rajya Sabha, if the Prime Minister is not a member, so if the Prime Minister is a member of the Lok Sabha, then he appoints somebody as a member, somebody from his party or somebody as the representative of the or of him as the leader of the House in Rajya Sabha. Then he commands over the bureaucratic machinery, access to media, projection of personalities during elections, prediction as national leader during international summits, as well as foreign visits. The effects of collision on working of parliamentary executive. There have been growing discretionary power of president, necessity of much more consultation between political partners because there is erosion of the prime minister's authority because of the coalition partners, and there is a lot of balance which he needs to maintain in order to run that coalition government effectively. Then the restrictions on the privileges of the prime minister. So similar to the office of president, we have the office of governor in the state legislature. So governor, so most of them, many are the retired military officers or civil servants or politicians. This is not written in the constitution. This is just a general norm or the uh, general convention which we see. Then the governor is appointed by the president on the advice of the council of ministers. The governor has discretionary powers. The powers to recommend dismissal of state government and the dissolution of the assembly. Is the power to reserve a bill passed by the state legislature for the assent of the president. Then the bureaucracy, the professional administrative machinery, and also politically accountable. The legislature also exercises control over the administration. Officers cannot act in violation of the policies adopted by the legislature, expected to be non-partisan. Participate in the drafting the policy and its implementation, selected on the basis of merit by the UPSC or the state PCS, the state public service commissions. Then the removal or suspension is subject to a thorough inquiry made by the Supreme Court. Then there are reservations of jobs for SCs, STs, OBCs, and women to ensure more effective representation. So civil services has been basically classified into three categories. First is the All India service, then central service, then the state service. So the All India services is basically has the administrative service, the police service, and also the forest service. Then central services have Indian Foreign Service, Indian Revenue Service. State services have the sales tax officers. So the IAS, IPS, or IFOS are appointed by the state government under the supervision and control of the central government. So appointed by the central government in the state government under the supervision and control of the central government. So let's talk about the parliament. Parliament has a bicameral legislature, so where there are basically two houses to have more representation. Uh, Only five states in India have bicameral legislature: Bihar, Karnataka, Maharashtra, UP. It was formerly Jammu and Kashmir, but we have Andhra Pradesh and Telangana. So UP, Bihar, Karnataka, Maharashtra, Andhra Pradesh, Telangana. In bicameral, every decision is reconsidered. The parliamentary privilege is that no action can be taken against a member for whatever the member may have said in the legislature. So they have a much wider extent of the freedom of speech in the legislature. The presiding officer of the legislature has the final powers in deciding the matters of the breach of privilege. Then Rajya Sabha. Rajya Sabha is the permanent house of the parliament. It represents states or the federal nature of the Indian constitution. So the Rajya Sabha members are indirectly elected by the members of the legislative assemblies of the states with a third variant of proportional representation and single transferable vote. The number of members to be elected is fixed by the fourth schedule of the constitution. Fourth schedule of the constitution. Then the seats for a state are in accordance with their population. More population would mean more seats. So the members are elected for a term of 6 years. Every 2 years, one third of the members of the Rajya Sabha complete their term, and the elections are done for these one third of the seats. Even when the Lok Sabha is dissolved, Rajya Sabha can be conducted for urgent matters. There are 12 nominated members by the president, members from different remarkable fields like art. Uh, then the functions of parliament. The function of the parliament is to enact legislation, bills drafted by the bureaucracy under supervision of the Council of Ministers. The members other than the Council of Ministers can also introduce bill, but these have no chance of being passed without the government support. So these are basically the private member bills. Then the control of executive and ensuring its accountability. This is the major function of the parliament. So they have the no confidence motion also in order to uh, implement its control on the executive and ensure its accountability. Then the financial function. It controls taxation. Government has to give an account to the legislature about the money spent and resources it wish to raise. The annual budget, which is also called as the annual financial statement. So the legislation ensures that the government does not misspend or overspend. There are also various committees in order to gauge that. So these are basically the estimates committee and the public accounts committee and the committee on public sector undertakings. So uh, it represents divergent views. There is a debating function where members are free to speak on any matter. There is constituent function, the power of discussing and enacting changes to the constitution. So the constitution, the Indian constitution is basically a living document, and there have been changes from time to time. It is not a very rigid document. It has been flexible, although the rigidity has also been kept intact in some matters. So in some matters, you need to have a more larger view or a larger extent of majority or, or assent from the uh, members of the parliament. So it has both rigid and flexible features, but it is a living document. So the constituent function, then the constitutional amendments are approved by special majority in both the houses. So half majority or half of the more than half of the strength of the house, total strength of the house, where and two-thirds of the member present and voting. In the electoral functions, it elects the president and the vice president. The judicial function is that it considers proposals for the removal of president, vice president, and judges of the High Court and Supreme Court. The conduct of the judges of the Supreme Court and High Court could not be discussed in the Parliament unless it is for the resolution for removal. Then the powers of the Lok Sabha and the powers of the Rajya Sabha. The Lok Sabha basically makes laws on matters included in the union and the concurrent list. It can introduce and enact money bills and non-money bills. It approves proposals for taxation, budgets, and annual financial statements. It is the one who could vote for the demand for grants. So it controls the executive by asking questions, supplementary questions, resolutions, and motions through the no confidence motion. It can amend the constitution, approves the proclamation of emergency, elects the president and vice president, and removes judges to the Supreme Court, establishes committee and commissions and considers their opinion. Then the powers of the Rajya Sabha. It considers and approves non-money bills. So money bills are just the forte or the exclusive right of the Lok Sabha in order to like pass the money bills. You have to just introduce and vote for it in the Lok Sabha. Rajya Sabha has no authorization for money bills, so it can only consider non-money bills and suggest amendments to money bills. So these amendments can either be incorporated or it can be foregone by the Lok Sabha. It also approves constitutional amendments. So in the terms of constitutional amendments, both have equal power. Then it exercises control over the executive by asking questions, introducing motions and resolutions. So notably, no confidence motion can only be passed in the Lok Sabha and not in the Rajya Sabha. So the participates in the election and removal of president, vice president, judges of the Supreme Court and High Court. It alone can initiate the process for the removal of the vice president. So this is an exclusive power. After the resolution alone is passed in the Rajya Sabha, the Lok Sabha only has to provide its assent, only has to agree. Then it can give the Union Parliament powers to make laws on matters included in the state list. It can also pass a resolution for the creation of all India services. Then the powers of the Rajya Sabha can give Union government powers to remove matters from state list and add in Union or current list. So over here, in the power exercised only by the Lok Sabha. Council of Ministers is responsible to the Lok Sabha only and not the Rajya Sabha. The Lok Sabha can initiate, reject, or amend money bills. Amendments for money bills suggested by the Rajya Sabha may or may not be accepted by the Lok Sabha. It can inquire into the cases of misuse of funds on the basis of the reports of the Comptroller and Auditor General and the Public Accounts Committee. So the lawmaking, in terms of lawmaking, there are basically two types of bills. First is the government bill, then we have the private members bill. So the government bill and the private members bill, they can be both money bill and non-money bill. Non-money bill can be an ordinary bill or a constitutional amendment bill. So preparation of bills involves resources required to implement the law, support or position that the bill is likely to produce, the impact that the law may have on the electoral prospect of the ruling party, etc. The draft opinion is prepared by the concerned ministry. If a non-money bill is passed by one house, it is sent to the other house where it goes through exactly the same procedure. So if it is passed in Lok Sabha, then it has to go to Rajya Sabha and it has to follow the same procedure only for a non-money bill. In case of disagreement, joint session of parliament is called to resolve it. The decision has always gone in favor of Lok Sabha because first it needs the joint seating. If a bill is gone to the joint seating of the parliament, then it has to be passed by a simple majority, and you have to see this. This is the strength of the Lok Sabha. This is the strength of the Rajya Sabha, and you need a special majority. So you just need half of 543 plus 250. So you just need half of this. So definitely the Lok Sabha would win. So it definitely would go in the favor of the Lok Sabha. Also, the Speaker of the Lok Sabha is the presiding officer for the joint sessions of the Parliament. The money bill, in terms of money bill, Rajya Sabha can either approve the bill or suggest changes, but it cannot reject it. If no action is taken within 14 days, the bill is deemed to be have passed. The Article 109 says that the money bill shall not be introduced on the Rajya Sabha. So the budget actually can be introduced, but it cannot be voted upon. Anyways, just have a look at this article. When a bill is passed by both the houses, it is sent to the president for his assent. The president can provide his assent, or send it for reconsideration, or can withhold his assent. So it cannot send back for reconsideration in terms of the constitutional amendment bills and money bills. In terms of constitutional amendment money bills, he has to eventually provide his assent. In terms of money bills, president is like there's prior uh, approval, or there's prior recommendation of the president involved. Then only the bill is then introduced into the uh, houses of the parliament. So president is the one who causes for the introduction of the money bill into the parliament. So the instruments for of parliamentary control, the deliberation and discussion. The question are, this is an Indian invention. Sorry, zero hour is an Indian invention. The question hour is this is held every day during the sessions of the parliament, when where ministers have to answer the questions raised. Most effective method of keeping vigil on the executive and administrative agencies. Then we have the zero hour. Members are free to raise any matter. Ministers are not bound to reply though. Then half an hour discussions on matters of public importance. We have the approval and ratification of laws. Then the financial control, preparation and present of the budget for the approval of the legislature is a constitutional obligation of the government. Then another instrument of parliamentary control is the no confidence motion. So even if the no confidence motion is passed on one of the members of the Council of Ministers, then all of them have to resign. Then the committees of the parliament. These are the mini legislatures. These were developed. These developed a system of parliamentary standing committees since 1983. Over 20 such departmentally related committees are there. So we have 24 DRSCs studying the demands of grant, looking into expenditure incurred by the various departments, investigating the cases of corruptions. Standing committees supervise the work of various departments, their budget, their expenditure, and bills that come up in the House relating to the department. Joint parliamentary committees can be set up for discussing a particular bill. So basically, there are two types of committees in the parliament: permanent or ad hoc. So these joint parliamentary committees are basically set up for a particular reason, and then they resolve after that reason all that matters done with. Then the members of these committees are selected from both the houses. However, the members of the estimates committee is only from the Lok Sabha. It contains 30 members. And the committee system has reduced the burden on the parliament because there is more deliberate discussion, and these committees basically prepare all those reports and then pass it on to the parliament so that they could discuss and they would know the nitty gritties of the past bills or the demands for grants. Then the parliament rarely rejects decisions made by these committees. The regulation of the parliament. The relation of the parliament is through debates. The presiding officer of the legislature is the final authority in the matter of regulating the business of the legislature. Then we have the anti-defection law. This was enacted by the 52nd Constitutional Amendment Act in 1985. So 52nd Constitutional Amendment Act in 1985, which added a 10th schedule to the Constitution. This was also modified in the 91st Amendment. So in the 91st Amendment, we also made a provision that the Council of Ministers should not be more than 50% of the seats in Lok Sabha. Then the legislature who is elected on one party's ticket must be restricted from defecting to another party. If a member is proven to be defected, he loses his membership of the House. Also disqualified from holding any political office like ministership. Defection is if a member remains absent in the House when asked by the party leadership to remain present, or votes against the instruction of the party, or voluntarily leaves the membership of the party. It is deemed as defection. So this was all about the parliament. Now let's go on towards the judiciary. So let's start with the independence of the judiciary. The executive and legislature must not restrain the function of the judiciary so that it cannot do justice. The legislature is not involved in the appointment of the judges. So they basically follow the collegium system. So the appointments are totally independent of the legislature. In order to be appointed as a judge, a person must have experience as a lawyer and or must be well versed in law. Judges have the security of tenure. These are not financially dependent on either organs. Salaries and allowances of the judges are not subjected to approval of the legislature. So these are basically charged on the Consolidated Fund of India. The judiciary has power to penalize those who are found guilty of the contempt of court. Then the parliament cannot discuss the conduct of the judges except when the proceedings to remove a judge is being carried out. The appointment of the judges. The Council of the Ministers, Governors, and Chief Ministers and CJI, all of them influence the process of the judicial appointment. But mostly it is the collegium system. Then the Chief Justice of India, a general convention whereby the senior most judge of the Supreme Court is appointed was appointed as the Chief Justice of India. Other judges of the High Court and Supreme Court are appointed by the President after consulting with the CJI. The final decision in matters of the appointment is rested with the Council of the Ministers. So there have been three or four judges case. The last one was about the NJAC and the repealment or the abrogation of NJAC, National Judicial Appointment Committee. Then the after Supreme Court judges, so CJI should recommend names of person to be appointed in consultation with the four senior most judges of the court. This is called the principle of collegiality. So the collegium system. So CJI can only recommend the names after due consultation with four other judges of the Supreme Court. So the removal of the judges is extremely difficult. Judges can be removed only on the grounds of proven misbehavior or incapacity. The motion for removal must be approved by special majority in both the houses of the parliament. So both Lok Sabha and Rajya Sabha have equal say in the process of the removal of the judges. While in making appointments, the executive play a crucial role. The legislature has the power of removal. So appointments are done by the executive. The removals can be done by the legislature. So far, only one case for removal of a judge of Supreme Court was there in 1991 for Justice Ramaswamy. We got 2/3 of the majority, but did not have the support of the majority of the total strength of the House. Hence, he was not removed. The structure of the judiciary, though integrated in structure, it is a pyramidal one. So it is a downward pyramid like this. So, or you could say this also, because at the apex you have the Supreme Court at the apex. Yeah. The Supreme Court of India, decisions are binding on all courts and transfer judges of the High Court. Can move cases from any court to itself and transfer cases from one High Court to another. So there have been two writs which are basically for transferring cases and basically for the administration of the basically for transferring cases from the lower courts to the upper court. Two writs which are prohibition and certiorari. So the High Courts can hear appeals from lower courts, can issue writs for restoring fundamental rights as well as legal rights. So High Court has a wider writ system. High Courts can deal with cases within the jurisdiction of the state. It exercises superintendence and control over the courts below it. The district courts deal with cases arising in the district, considers appeal on decisions given by the lower courts, besides cases involving serious criminal offences. Any subordinate courts consider cases of civil and criminal nature. We also have the alternate dispute redressal mechanism. The jurisdiction of the Supreme Court. It has original, appellate, advisory, writ jurisdiction as well as some special powers. The original jurisdiction says that it can settle disputes between union and states and among the states. According to the appellate jurisdiction, it tries appeals from lower courts in civil, criminal and constitutional cases. It advises the President on the matters of public importance in law, Article 143. Then the writ jurisdiction can issue writs of habeas corpus, mandamus, prohibition, certiorari, quo warranto to protect the fundamental rights of the individuals. Special powers, it can grant special leave to an appeal from a judgment or matter passed by any court in the territory of India. So special leave to an appeal. Person can appeal to Supreme Court against the decision of the High Court. However, High Court must certify that the case is fit for the appeal. That is to say that it involves a serious matter of interpretation of law or constitution. In the advisory jurisdiction, President can transfer any matter of public importance to Supreme Court for advice. Supreme Court is not bound to give the advice on matters, and the President is not bound to accept such an advice. Supreme Court is actually not bound to give advice on some certain matters, and President is not bound to accept such an advice. The utility of advisory power of Supreme Court. From Article 137, Supreme Court has the power to review any judgment pronounced or order made by it. According to Article 144, all authorities, civil and judicial in India, shall act in aid of the Supreme Court. It allows the government to seek legal opinion on matters of importance before taking action on them. In the light of the advice of the Supreme Court, the government can make suitable changes in the action or legislation. The judicial activism. The emergence of the public interest litigation and the social action litigation. In 1979, public interest cases can be filed even by others or on the aggrieved person's behalf. Judiciary began considering many cases merely on the basis of the newspaper reports and postal complaints received by the courts. PILs are now acceptable in South Africa. It is the fundamental right of the citizens to bring before the Constitutional Court cases of violation of other persons' right. So this is the General Convention in South Africa. Then the pros of judicial activism. PIL expanded the ideas of rights. Judiciary has shown readiness to take into consideration the rights of those sections who cannot approach the courts easily. Judicial activism democratizes the judicial system by giving not just to individuals but also groups to access the courts. It forces the executive accountability, attempts to make the electoral system more free and fair. Courts ask the candidates to file affidavits indicating assets, income, education. But the cons of judicial activism are it has overburdened the courts. It has blurred the line of distinction between the executive, legislature, and judiciary. It made the balance between the three organs very delicate, and our constitution is based on the separation of these three organs, the legislature, executive, and judiciary, the separation of power between the three of them, and it has also been incorporated in Article 50 of the PSP. It has been creating strains on democratic principle of respecting power and jurisdiction of other organs. The provisions of Constitution for Supreme Court as protector of fundamental rights and interpreter of the Constitution. These powers have been given by the issuance of writs. Article 32 for Supreme Court, Article 226 for the High Courts. Then Article 13 says that Supreme Court can declare the concerned law unconstitutional if it is in violation of the fundamental rights. So this is also one of the interpretations in order to give into effect the idea of judicial review. Then moving on to federalism. General features are that two sets of policies, one at the national level, other at the regional level. Each government is autonomous. Some countries have a system of dual citizenship. People have two identities and loyalties, one for the state, one for the nation. The constitution is the guiding criteria, independent judiciary in order to resolve the disputes. So the features of federalism in India which were incorporated in the Indian constitution are first according to Article 1. According to the makers, principles of unity and cooperation between the center and the states and separation of powers of the states. So according to Article 1, we have the Union of States. The Union of India, basically, in the Union of States. India is a union of states. Uh, Economic and financial powers are centralized in the hands of the central government. We have a quasi-federal system where we have a strong union government, so central stronger than the states. The parliament can alter the boundaries of states and can form new states, though constitution has some safeguards. There are emergency provisions. Power becomes lawfully centralized during emergency conditions. Parliament assumes the power to make laws on subjects within the jurisdictions of the states. So, like assume the powers on the state list as well. Then we have the plan. We had the planning commission, which was appointed by the union government, which was a coordinating machinery that controls and supervised the resource management of the states. The union government used its discretion to give grants and loans to the states. But now we have the Niti Aayog from 2015. So this institution of planning commission is in no longer active. And then Article 257, executive powers of the center are superior to that of the states. IAS or IPS are under union government control and states cannot take disciplinary action against them. Article 33 and 34 authorize Parliament to protect persons in the service of the union or state in respect of any action taken by them during martial law to maintain or restore order. Armed Forces Special Protection Act has been made on the basis of these provisions. So there have been some contentions about the Armed Forces Special Protection Act in the states of in some northeastern states, which was recently in news. Then we have the central-state relations. These are influenced by the nature of political process. A demand for autonomy, more power to states by Tamil Nadu, Punjab, West Bengal. Then the financial autonomy, the independent source of revenue and greater control of resources for the states. These are the demands for autonomy by the states. States present the control of the center over the administrative machinery. So the administrative machinery, which are the IS and IPS officers, which are actually under the union control, but they work in the states. So states are presenting the control of the center over the administrative machinery. Related to the cultural and linguistic issues. The conflicts of ideas due to provisions of President's rule and the power of governor to recommend the dismissal of the State Assembly. Then we have the Sarkaria Commission, which was appointed in 1983. It submitted its report in 1988. It was appointed by the central government in order to examine the issues relating to central-state relations. It recommended that the appointments of governors should strictly be non-partisan because the governor is basically said to be the agent of the center in the states. So it should be somebody who is non-partisan, who doesn't take sides, impartial one. Then the demand of new states. In 1984, the States Reorganization Commission was set up. It recommended the creation of linguistic states, at least for the major linguistic groups. Then in 1956, the reorganization of states was done. Andhra Pradesh was the first one in order to be formed because of linguistic criteria. The interstate conflicts. Uh, so the interstate conflicts are basically the border disputes over sharing of river water. So the sharing of this river water was recently in news because of the Kaveri river basin and disputes over it between the states of Tamil Nadu, Karnataka, and Kerala. Also Puducherry, but mostly Tamil Nadu, Karnataka, and Kerala, as far as I remember. Then, in the special provisions, peculiar social and historical circumstances, because of some of these peculiar social and historical circumstances, there have been some special provisions provided to some of the states. So, according to Article 371, the provisions for Northeast, due to indigenous tribal population with a distinct history and culture, which they wish to retain. Also for the hilly states like Himachal Pradesh and the states like Andhra Pradesh, Goa, Gujarat, Maharashtra, Sikkim. Also there was Article 370 for the state for the erstwhile state of Jammu and Kashmir, which was removed on 5th of August 2019. So according to it, the reason was that most of the Muslim majority states joined Pakistan except Jammu and Kashmir. So the central government has had only limited powers according to Article 370. The state of Jammu and Kashmir had a separate flag. Union concrete list can only be used with the consent of the state government. There was a constitutional provision that allows the president, with the concurrence of the state government, to specify which parts of the union list shall apply to the state. So more power was with the state of Jammu and Kashmir than with the center. The president had issued two constitutional orders in concurrence with the government of Jammu and Kashmir, making large parts of the constitution applicable to the state. No emergency due to internal disturbance can be declared in Jammu and Kashmir without the concurrence of the state. The union government cannot impose financial emergency in the state, and the DPSP do not apply in J&K. The amendments to the Indian Constitution under Article 368 can only apply in concurrence with the government of Jammu and Kashmir. So you could see that there was more emphasis on the state government than that of the center, unlike the rest of India. So ultimately, in the year 2019, this the Article 350 was removed. It was repealed, and Jammu and Kashmir was bifurcated into two union territories. The first is the union territory of Ladakh, and then the union territory of Jammu and Kashmir. So recently there have been Jammu and Kashmir elections also, where the union territory of Jammu and Kashmir also got the elected assembly, just like the states of Delhi and Puducherry. So the local governments. Local governments are basically the instruments of decentralization and participatory democracy. The pros are that it helps in the efficient and people-friendly administration. They facilitate convenience for people to approach. Then the historical features in the formation. Local bodies created after 1882 by the Lord Ripon, the then Viceroy, called local boards. Lord Ripon is also instrumental, and he is said to be the father of the local self-government. In following the Government of India Act 1919, village panchayats were established in a number of provinces. Mahatma Gandhi had strongly pleaded for the decentralization of economic and political power. The subject of local government was a DPSP. The turmoil, and this DPSP is basically called a Gandhian feature or Gandhian principle of DPSP. The turmoil due to the partition resulted in a strong unitary inclination in the constitution. According to Nehru, it was a threat to unity and integration for the nation. Dr. B.R. Ambedkar felt that the faction and caste-driven nature of the rural society would defeat the noble purpose of the local government at the rural level. Hence, there were different programs. One of them is the Community Development Program of 1952. It sought to promote people's participation in local government. It recommended a three-tier Panchayati Raj system. Gujarat and Maharashtra adopted local body system in 1960. The local government is dependent on state and center for financial assistance. In 1989, the P.K. Thangan Committee recommended constitutional recognition for the local government bodies. A constitutional amendment to provide for periodic elections to local government institutions and enlistment of the appropriate functions to them along with the funds was recommended. So it basically recommended the constitutionalization of this feature of the local self-governments in order to incorporate it in our constitution so that we have a constitutional basis for the formation of these. The aim of the 73rd and the 74th Amendment Act, introduced in 1989 and passed in 1992, they came into force in 1993, was to strengthen the local governments and ensure an element of uniformity in their structure and functioning. So, until these amendments, the local governments was basically formed according to the will of the states, and therefore they had different functions according to whatever was devolved by the states. But now this attempt was of introducing the 73rd and 74th Amendment Act was in order to ensure an element of uniformity in the structure in all of India with regards to the local governments. So the 73rd Amendment Act was about the Panchayati Raj institutions. It had a three-tier structure. On the top is the Zilla Panchayat, which covers the entire rural area of the district. Then the intermediate level is the mandal or the block or taluka. It needs not be constructed in small states. Then at the lower level or the grassroots levels, we have the gram panchayat. It's mandatory for the creation of the gram panchayat, comprised of all other voters in the panchayat area. The term of each body is 5 years. If the state dissolves it before 5 years, then fresh elections must be held within 6 months of the dissolution. One-third of the seats in the panchayati institutions are reserved for women. The reservation for SC and STs or OBCs in states won in proportion to their population. Reservations are applied to the positions of chairperson as well. 29 subjects transferred to PRIs from state list earlier in 11th schedule. Uh, the states decide how many of these 29 subjects will be transferred to the local bodies. It is not applicable to the states inhabited by the Adivasi population in many states. So the schedule 5 areas, it is not implemented over there, but now they are having provisions. So after that, this was implemented. Then in 1996, another act for extending these panchayati institutions to these areas, more power to the Gram Sabhas. As I told you earlier, the panchayats need consent of the Gram Sabha in many matters. Moving on to the State Election Commission. It is an autonomous body appointed by the state, independent officer not linked to the Election Commission. The State Finance Commission, it is also appointed by the state once in 5 years. It examines the financial position of the local governments. It reviews the distribution of the revenues between the state and the local government. So the urban for being an urban area, the minimum population should be 5,000. At least 75% of the male working in the non-agricultural sector. Density of population at least 400 persons per square kilometers. So the 74th Amendment Act was done for the local bodies or Nagarpalika, Nagar Parishads. It is a repetition of the 73rd Amendment Act but applies to the urban areas. So the pros of the 73rd and 74th Amendment Acts. They created uniformity in the structure of the panchayati institutions as well as the urban local bodies. They ensured the presence of women. A new perspective and greater sensitivity was provided. Although also there were some cons as well. Many states have not transferred most of these subjects to the PRIs. Does not change the way in which decisions are taken at the central and the state level. People at local level do not enjoy much power of choosing welfare programs or the allocations of resources. They have been dependent on state and center for the financial support. So lack of finances is one of the reasons of the cons. Then the amendment to the constitution. So what is the procedure to actually amend the constitution? So there are three basic categories in order to amend the constitution. First is simple to ordinary law. So for simple to ordinary law, we need simple majority in the parliament, as mentioned in some articles. Then special majority is needed in parliament in both houses separately, as per Article 368. Then special majority plus legislatures of half the states have to ratify. Uh, this is also mentioned in Article 368. So three types of amendments can be done. Then president has no power to send it back for reconsideration. So president can either provide his assent or withhold the assent. He cannot send it back for reconsideration. And the types of amendments. First are the technical ones. It makes no substantial difference to the original provisions, just elaborate it or some minor modifications to it. Then the differing ones, where there are different interpretations by judiciary as well as legislature. So, for example, the right to property. Then after that, the case of Keshavananda Bhartiya case in 1973 was judgment came, and 24th Amendment, Constitution Amendment Act. So that sort of the different ones. Then third is through political consensus. For example, the minimum age of voters was changed from 18 years to 21 years. So this statement right here I've written wrong. It is from 18 years. Sorry, like the minimum age of voters from was changed from 21 to 18 years. I really was confused. Yeah. Then the controversial ones like 38, 39, 42nd. 42nd Amendment Act is basically called as the mini constitution, subverting the constitution by the ruling part. Then in 1975, internal emergency, it ran it brought 38, 39, 42nd amendments to make changes in crucial parts of the constitution. It aims to override the ruling of the Supreme Court in Keshavananda Bharti case of 1973. So this was a landmark judgment from the Supreme Court, and there was an attempt to override it. The duration of the Lok Sabha was changed from 5 to 6 years. Fundamental duties were included in the Constitution by Article 51A. This was on the recommendations of the Swaran Singh Committee. So Swaran Singh Committee. Then the restrictions on the review power of the judiciary, changes to the preamble, seventh schedule, and total 53 articles were changed. So preamble they added socialist, secular, and integrity. So these keywords were added to the preamble by the 42nd Constitutional Amendment Act. After the 1977 elections, the new government cancelled most of these by the 43rd and the 44th Amendment Act. So these were basically in order to uh, rectify the mistakes which were done. Then the review of the Constitution in 2000. This was appointed by the Government of India. Chairman of this committee was the Chief Justice of Supreme Court, Justice Venkatachalaya. Stuck to the theory of the basic structure and did not suggest any measures that would endanger the basic rights of the Constitution. So it upheld the provisions of the basic rights, which was basically derived after many Supreme Court judgments, especially the monumental Keshavananda Bharti case. Then the limitations of the Indian Constitution. It has a centralized idea of the national unity, so central greater than the states. Some important provisions were mentioned in DPSP rather than including in the FR, the fundamental rights, because of various reasons, and one of the prominent reasons given by the constitution makers was the diversity in our country and the need to unite this vast nation and the after effects of the Indian freedom struggle and obviously after the partition. Then the constitution did not lay emphasis on important issues of gender justice, particularly within the family. So the issues of patriarchy, misogyny, these were not even addressed. So with this, we've come to an end on our discussion on the class 11th book of Constitution at Work. So I hope this might have helped you uh, in order to have a summary of this very book. So I'll see you guys in the next video. Till then, see ya. Bye.